one of the things that I remind salespeople is that we are not the, sorry, my OCD. We are not the keepers of available properties for sale or for lease, are we? 1,000 years ago, there used to be books the size of telephone books that were sent to brokerage offices. That was the MLS. That's what it was. It was books. And they had to come to the office. And they had to review the books. And they had to talk to you to know what properties were available. Not anymore. Not for, what, 15 years, right? So, and more websites are popping up, more and more ways to get that availability. So buyers and tenants don't need you for that, okay? So that's important for you to remember. You are now going to need, especially when you're going to a buyer and you're saying, you're hiring us and we're charging a fee, you're gonna need to say, you're gonna need to show your value, right? You're going to have to explain to them why. Oh, because the law said I had to. Well, yeah, the law said you had to have an agreement in order to be compensated, right? But you need to tell them, because now you're going to be competing against different brokers who are going to have different fees. So if your fee is up here, that's fine. But have a value proposition to support that. It's same with a listing, right? Your fee might be here, another broker's fee might be here, another broker's fee might be here. It's about the value, not necessarily about the cost. You're now going to have buyer consultations. I love buyer consultations. I always did buyer consultations. That's an opportunity to sit down, review the process, show your value, get their needs assessment, the must-haves and the would-like-to-haves, right? It's going to be showing them the sales contract. These are the things we're going to have to know when we submit an offer so that it's not a surprise. One of the worst experiences buyers have is surprise in this process. We do this every day. We do this every day. We know this process backwards and forwards, which is great. That's why they hire us. But in the same way that in the same way you interact with any professional, if you go to an attorney, they know the law backwards and forwards, but they have to explain it to you so that you understand it. It can't be, oh yeah, the next thing is a home inspection. You better get a home inspector, right? That's part of the buyer consultation. It's reviewing the entire process with them, okay? So we're going to need to do that. And then, of course, getting your pre-approval done. I want to give you 3 tips that I used as a salesperson, but I also want, it's tips that I use in my own brokerage, and they're tips I want to share with you because it's applicable to everybody. Tip number 1, don't send listings to buyers. Don't send listings to buyers, okay? How many of you go in the MLS, set up an auto email campaign, and send listings to buyers as they come out? For those of you who are shaking your head, hopefully you're licensed with me. Don't send listings to buyers, right? The MLS is a great tool for getting that information, but it is only as accurate as the listing agent who entered it, okay? Do you know there's a big difference between a Cape Cod and a Colonial? Do you know there's a big difference between a split level and a bi-level? I can honestly tell you, I didn't know the difference when I got into real estate. I didn't. But as part of my learning process, I learned the differences, right? When you have a bi-level property house for sale, and you list it as a split level, or you have a Cape and you list it as a Colonial, now you're sending these auto email listings to everybody, and to your clients, and they say, well, we want Colonials, and you send them a Cape. Guess what they think about you? They think they didn't hear me. They didn't hear me. They didn't hear me. Set up those auto campaigns, but send them to you. You get the email every day, not them. And in my email, I would always have, there's a place where you can, different MLSs have different processes, but at least I'll speak for Garden State MLS. They have that spot where you can have a message that says, oh, these are new properties, and they just get that every day, right, every time something comes. I would fill that in with their names, with their needs assessment, what they were looking for, and I would look at the listings. If they said, we want a colonial and nothing else, I am not sending them cable, right? If we want a bi-level and nothing else, I'm not sending them a split. Now, if I see a property that might work for them based on I'll say, here's what you asked for, and then here's some other options you might want to consider. Make sense? But you're sending the email. It's coming from you. And every day, I would get, for every buyer I worked with, every tenant I worked with, I would get that list every day. Is it time consuming? Sure. But guess what? I'm showing my value to them. And I never had a buyer walk away from me. Or go astray. Or go work with other agents. Right? Because I showed my value. The other tip number 2, the other piece of that, by the way, is if you send them things from the MLS, what happens if they want to look at more things? They're going to close that email, and then they're going to go on some website, let's not say names, but some website where, they might get a pop-up that says, interested in this? Schedule a showing. How many times have we had a buyer say, oh, well, I was just scheduling a showing. I wasn't working with them. Part of your buyer consultation is explaining how those websites work. Do not. You can go on those websites and look. That's fine. Don't click anything. Right? Don't click anything. Please. Don't click anything. Don't talk to, you can go to open houses, fine. But make sure you put my information. Your name, my information. They don't need your phone number. They don't need your email address. They have absolutely no reason to contact you directly when you're represented by an agent. Okay? Tip number 2, tell buyers when you don't have anything to tell them. Right? Tell buyers when you don't have anything to tell them. So, new properties may not be coming on the market. So you're going to say, well, I don't have anything to share with them. I guess we'll wait for tomorrow. No. Call them, email them, text them, whatever the preferred method is, and tell them, nothing came on the market. I just wanted you to know. I'm looking for you every day, showing your value. I'm looking for you every single day. And, other agents, other people, other buyers may know other buyers, right? And they might be in the process together with 2 different agents. Oh, who was that? Well, that was my agent. Oh. Well, what she or he have to tell you? Nothing. There's nothing on the market. It's been like that for the last couple of days. So we might have to adjust, our criteria. That's funny. I haven't heard from my agent in a week. Right? Tell them when you don't have something to tell them. Right? They don't know you're working for them unless you tell them and show them you're working for them. Tip number 3. This is my favorite. Ready? Write this down. Answer your phone and clear your voicemail. Do you know when you delete a voicemail, at least I have an iPhone, so I can only speak for iPhones. But when you delete a voicemail, it goes into this little la-la land called deleted messages, which still uses your voicemail storage. You actually have to go into deleted messages you deleted. You have to go in there and click a button that says clear it, so that your voice, especially now, and especially if you're a listing agent, you've got to have that available, right? You're not going to be able to answer the phone every single time someone calls, and you shouldn't. If you're working with a client, you don't answer the phone. But when you're working with that client and you have that value proposition, you set the expectations. You tell them, I may not be able to answer the phone every time you call, but I promise if you leave a message, I will get back to you within a certain amount of time, right? It's okay. We're allowed to be other places, okay? So please answer your phone and clear your voicemail. How am I doing on time? Been talking too much already? The sales contract. The sales contract does not and never has determined a broker's compensation. When you put in compensation amounts in a sales contract, that is for reference purposes only for our lender friends and our title company friends. The buyer and seller cannot, in a sales contract, agree to the compensation that brokers get paid. Because the agreement is not between them. The agreement is between the seller and the listing broker, between the buyer and the buyer broker. It's for reference only. Okay? So make sure it's accurate, but it's for reference only. Now I talked about, the seller compensating the buyer's broker. Well, that's going to have to be in the contract as a term. But that information page of the brokerages that are involved and the compensation that's there, that's not actually a term of the contract. Yes, sir.
I'm so glad you just mentioned that, because I just had a file that came out of underwriting yesterday.
Mm-hmm.
The underwriter was requesting exactly what you just said.
Mm-hmm.
They're saying we need to see the agreements. So, great point.
Well, I may disagree on that point, but in the same way that the listing brokers have never sent their listing agreements to lenders, so it should not be.
It's the buyer agent agreement.
I understand, but it should not be necessary for the lenders to receive the buyer broker agreement. I won't
It's not our
forbid
guideline,
it.
it's in Fannie Mae guideline.
Yeah, okay. Well, that's, yeah. I mean, I have a very differing point, on that. But it's not for me to, dispute it now. But that's for reference only. And I want you to think about that just for a minute. You could put in the compensation, let's say there was an offer of compensation of so much, and you put a higher amount in there, and the seller and buyer sign. Does that mean that that's the compensation that gets paid? No. Because the seller and buyer can't agree together what compensation gets paid to the different brokers. Okay? It's put in the contract for reference purposes. Most brokers are also getting this wrong in that they're saying, put those figures there. If everybody agrees on it, as far as, yeah, that is the correct number, that's fine. But I also want you to think about it from this perspective. If those have to be put in there, then if you were the buyer's agent filling out the contract, you now have to reach out to the listing agent and say, oh, what's your commission with the seller? Because I have to write it in the contract. In my opinion, as helpful as they are, those boxes shouldn't be used. They shouldn't be used.
So leave them blank?
My advice is leave them blank. Because if there's compensation that's going to be paid, every lender is, you're going to walk out right now. It's like shuddering, right? The agreement is between the buyer and the buyer broker, right? The agreement is between the listing and listing broker. The only thing referencing compensation that should be in that contract is the request from the buyer for the seller to compensate their broker. Because that's an agreement that two of them can have, not that specific reference. So I want to give you two phrases. I am actually almost done. I want to give you two phrases that'll be helpful to you. One is if the buyer is asking for the buyer broker fee to be paid from the seller in the form of a concession. Now we've already talked about how that's probably not the best idea, but here's some language for you. Under the additional contractual provisions of the contract, seller to credit buyer, whatever the amount is, at close of escrow to satisfy buyer's contractual agreement with buyer's broker. I'll say it again. Seller to credit buyer, whatever the amount is, at close of escrow to satisfy buyer's contractual agreement with buyer's broker. That is when it is in the form of a concession. The better way to do it is direct compensation from the seller. Still needs to be in the contract. The verbiage is a little different.
To satisfy what? One more time.
To satisfy buyer's contractual agreement with buyer's broker. So the direct payment from seller is similar but a little different. Seller to compensate buyer broker. Not credit buyer broker, we can't get credit. Seller to compensate buyer broker, whatever it is, at close of escrow to satisfy buyer's contractual agreement with buyer's broker. Right? See the difference? So one is a credit to the buyer in the form of a concession, and that compensation will appear on the closing disclosure for the buyer. Whereas if it's seller to compensate buyer broker, now it will be on the seller's side, where it has been for a long time. Okay? These must be in the contract because it's a term of the contract. The request for payment of that compensation has to be in the contract. One of the things we did in our brokerage is we use a platform called Workplace, which is a business version of Facebook created by Meta. And ironically, it's shutting down, but it's a great tool, and we'll have a different one to use. But in there, we created a post. It was called Important Updates to New Jersey Forms. And we took everything, working with sellers, working with buyers, working with landlords, working with tenants. It's all in one post. Here are all the forms you need. Here's what they're for. And all you have to do is use them, right? Made it very, very easy. Explanations of things like compensation versus cooperation, right? Things like that, so that EXP Realty agents have those tools, okay? I mentioned the open house sign. You know, we created our own version of it, which just has a little description from the CIS of what the different agency relationships are. So that's the version that we created for both, one for buyers and one for tenant or lease open houses. Just remember, you always need to have the CIS at the open house, because remember, you know, you have, this is actually a funny change to the law. It's funny to me anyway. These things humor me, sorry. This sign is now required in an open house to explain who the open house agent is. It says, this is to advise you that the agent who is conducting this open house represents the seller and is required by law to promote the interests of the seller. Any information you give this agent is not considered confidential, etc., 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 etc. Do you know we've always been required to say that? Every consumer that comes to an open house, you have to explain the CIS. You have to explain who you are. Every prospect who you speak to on the phone, you have to explain the CIS. You have to form the context for the conversation. Because if you're not representing them and you're acting as a seller's agent only or landlord's agent only, you do not want well, you do technically, but they should not be providing confidential information to you. Because if you did not explain that CIS, you've caused a big agency problem. Okay? So make sure that you always do that. EXP Realty created forms, listing agreement and buyer broker agreements. And we created these nationwide. We did not copyright them. We did not copyright them because we want, or we don't want. We want, I said want again. We would like other brokers to have these available to them and to use them in their business if they need something. It's plain language. It's easy to understand. It's reasonable size font. Anybody seen the New Jersey Realtors? If New Jersey Realtors sees this video, the hate I'm gonna get. Has anybody seen you've seen the new Jersey Realtors buyer agency agreement? The one that's 5 pages long. That is so this big, right? You need a magnifying glass to read it, and it has so many terms in it, right? Yeah, we need it, but there's a better way to do it, which is why EXP Realty created a buyer-broker agreement. It's 4 pages, but it's larger print, so it's easier to read, not so many terms. They also created, or we also, I'll say we, why can't I say we? We also created a single property buyer-broker agreement, so that maybe you meet a prospect, and it's kind of like dating. It's been explained like dating, where, you know what, here's just this one agreement for this one property. Let's see how it works out. If we want to go on a 2nd or 3rd date, maybe get engaged, right? Here's the longer term buyer-broker agreement. So we've made both of those available. So, you know, they are available publicly. If you're with a different brokerage and your broker is interested, all they have to do is reach out.
It's more like a prenup.
Well, it's a sort of, yeah.
Like a blind date.
Right, blind, yeah. One of the things that is required, speaking of the listing fees, New Jersey law still permits the sharing or the broker-to-broker compensation that I talked about earlier. So every listing agreement actually has to have that verbiage in it. I'm not going to say bad things about New Jersey. Just bleep that out. So the New Jersey Real Estate Commission requires language that says most brokers cooperate and compensate, and this listing broker is offering this amount, right? So that if the listing broker is not sharing commission, then that number is 0, right? And I can use that number because the broker is not sharing compensation. If the seller is compensating, it's still 0, because this is about the listing broker sharing compensation, not the seller directly compensating. See the difference? So any listing agreement that you see where it says an offer of cooperation, if you're still doing the old way, where you are taking one fee with the seller and then sharing it, then you have to put an amount in there. But if you are not, and it's only the listing side, then the offer of compensation from the listing broker is 0. Okay? It's a big difference. Big difference. If you put in a number there, you're saying that you or your brokerage are the ones who are offering that compensation versus the seller offering it. Okay? Big difference. It's a real big difference. So, I'm going to say one more thing and then we can do questions, unless you want me to leave. So updates needed right away. Any active listings that are in the MLS for sale or for lease, compensation fields were automatically removed from the MLSs, so there's nothing more you should need to do. But do know that, you know, if your brokerage has changed their process where they are no longer offering broker-to-broker compensation, then an amendment to that agreement needs to be made, especially if it's the MLS listing agreement. An amendment is needed to take out that broker-to-broker compensation, right? And now it's going to be compensation directly from the seller. Any active listings you have on the market for sale need a seller's property disclosure. Doesn't matter when they were taken. If they are on the market for sale now and they're active, a seller's property disclosure must be completed. And can I talk about seller's property disclosures and lead-based paint disclosures for a moment? If the property is listed in the MLS, please upload those to the documents section. Those are not yours. They're not yours to hold. They're not yours to wait for somebody to ask so you can gauge interest in the property. Those are required disclosures for buyers to see. Okay? I'm sorry? For rentals too. If there's a lead-based paint disclosure required, put it in the MLS documents, please. All active buyers need buyer agency agreements. That includes buyers who are under contract. In order for you to be compensated for any closing, you have to have a buyer's agency agreement in place. Which means if the seller is offering the compensation and you already know what that amount is because you're under contract, that's the amount that goes in the buyer agreement. And you simply have to explain to the buyer, this is a new law, it's a new requirement, the compensation is coming from here, which will cover this amount, but in order for me to be compensated and our brokerage to be compensated, we are required to have a signed agreement with you. Okay? What else? Any active tenants you're working with need a tenant agency agreement or a tenant broker agreement. So please make sure you have an agreement signed with tenants. Okay? Not the ones that have already closed. You need any tenant you're working with. Right. Okay? So, I don't know, what was that, 4 hours? So, those are the updates and things that I have for you today. I mean, I hope so far it's been helpful. I hope you learned something. I'm sure you have a lot of questions. Do we have time for questions? Who's our timekeeper?
Yeah.
We have time for questions, so, yes, question.
Why does the clients, the seller's disclosure, some of them are just putting a line through the disclosure, is that acceptable?
It's not acceptable. It says must complete a seller's disclosure. Writing a line through a piece of paper is not completing it. Okay? Yes?
Let's clarify situation with tenant and landlord.
Yes.
Because initially...
Don't mention amounts.
No.
Okay.
No, initially New Jersey has been known for tenant-paid commission for just tenant-paid.
Where the tenant compensates both brokers. Yep.
Florida, for example,
Mhm.
landlord
Okay.
compensate. What is going to be now? Who's
So-
paying our commission?
In New Jersey, it's actually not a true statement that it's known in New Jersey. It's actually common in North Jersey.
Okay.
In South Jersey,
Okay, I am from.
yeah, so in South Jersey, I have to know all these things for the entire state. So in South Jersey, the landlord has been known to pay using the first month's rent as the broker fee.
Because of the summer rental or it's
No.
included everything?
No, it makes sense. I want you to think of this logically. A landlord is hiring you to market their property and go in search of a tenant. Why is that for free? Why aren't they paying for that service? It doesn't make any sense, right? So it's going to depend on the negotiation of the lease. So at the very minimum, the landlord and the landlord's broker they're going to need to have a fee agreed to for the listing. So if you're working with the landlord, you say, in order to be your landlord's agent, this is the fee for our service as your landlord's agent. Just like the listing with a seller, this is our fee as the listing agent for the seller. The tenants will have their own fee with their tenant broker. So if you're working with the tenant broker, or you're working with the tenant, you're going to have a fee for the service representing them as a tenant, as a tenant's broker, right? Tenant agent. When it comes time for a lease to be put together, the tenant can request that the landlord cover that fee. The landlord can request that the tenant cover the fee. Whatever it is, right? Or each client pays their own broker.
And it has to be written in the initial agreement with the landlord, for example, because it's a new for landlord now
Mhm.
to pay.
The amount has to be in the agreement, yes, of what the landlord is expected to pay or wants a tenant to pay. So instead of, instead of putting a listing and saying, this is the total commission and this much is going to go to the listing broker and this much is going to go to the tenant's broker. We're not doing that anymore, right? So now this is our fee together, landlord listing agent. This is our fee together, tenant and tenant's agent, right? And during that negotiation of the lease, then that conversation can happen. The landlord may instruct you to inform tenant agents that they expect that fee to be covered. That's okay, but if the tenant doesn't want to do it, then the tenant can negotiate or not take that rental. One of the things we need to get away from is the old way.
The
Right.
assumption.
The old way. Valerie.
So I'm seeing, 2.5. I'm saying fees, writers,
Yes.
okay, that have a certain on it. I'm seeing company websites
Right.
that have a number on it.
Right.
Okay, that is something that EXP is not doing.
Correct. EXP Realty is not putting offers of compensation on our exprealty.com website. And again, there's a little confusion as to whether, because it applies to an IDX enabled website. So the question is it the entire website or is it just the pages where the listings exist? Like I've seen circumstances where brokers have a completely separate page that say offers of, here's the listing, here's the amount, here's the listing, here's the amount. Right. Again, based on, what I've told you here today, I still don't think that's a good idea, right? It should be negotiated as part of the contract, not a specific number. Because by putting a specific number, we're just going back to where we were and how we got here in the first place, right? Yes, Valerie.
The other thing that I would notice is there's now a line or a box on the listing that says seller is willing to do concessions.
Right.
And yes or no.
Right.
Okay. Why does that even need to be there?
I can tell you why it doesn't need to be there. I can tell you why it is there. It is there as a way to say the seller is going to contribute towards a buyer's closing costs. And part of a buyer's closing costs is going to include compensation,
But
right?
that's not really the right way to do it.
Well, that is correct. And so a seller should never, ever, ever say, yes, I am contributing concessions, or yes, I'm contributing concessions in this amount. Now you're committed to it.
Right.
How about instead, if there has to be a yes or no, and I don't recall if it's a required
It's a yes or
field.
no.
Is it a required field? I don't remember.
I don't see
So if it's not a required field, I would suggest not putting it. But remember, the listing is the seller's listing. So you're really supposed to be reviewing all of that with them. Even the property description, that has to be approved by the seller, right? You can't just make it up and put it out there. You're advertising their property.
The interesting thing though, Jeff, is that.
And then I'm gonna move on,
States-
Valerie. I mean, there's 8,500 other people here.
Questions always. The interesting thing though is that when you hit yes,
Uh-huh.
a notice comes up that says that you need to make sure that you have a buyer's, broker agreement, all right? And if you hit no or close, that means you need to talk to someone else, your broker.
I haven't seen that because I'm not in the habit of entering listings.
But it makes.
But
you
I
think.
will, yes,
It
so
makes
I
you
will
think
look at that because that sounds like a bad idea.
Right, yeah.
That sounds like a bad idea. Yes,
So you have a buyer's agreement for X amount,
yes,
and you've negotiated, your offer for the seller's property, and then they have come back accepting your offer and saying, okay, we also agreed to your terms of compensating higher than lower than what your buyer has agreed. So the seller will give
Okay.
you X minus one, and your buyer, are
Would
they
make up the
responsible
difference.
to make up the difference, correct?
Yeah, and that's gonna be a business decision by the broker. So the broker has the right to waive whatever the difference is, if they want to. My personal opinion is, because I've also heard that, of some who have suggested, well, we'll just put it really high, right? Because you can't earn more than that is,
Right,
than is in the agreement.
right.
So we'll just put, so if there's any offer from the other side, we're covered, so we're good, we can just waive the difference. Establish your value. This is an agreement between you and the buyer, providing a professional service for a fee, right? Not whatever I can get for it. What a silly business model, right? Whatever I can get for it. No. There should, and by the way, this has always been the case. You can having a buyer agreement or a tenant agreement that says, you know, however much we're charging, and then it says in the agreement, if the seller doesn't cover all of it, you are responsible for the difference. And so, but again, that can be waived if the broker agrees.
So if you decide to waive it, do you have to have a new agreement signed or?
The existing agreement should be amended. So not a new agreement, an existing agreement. You just cross through, put the new amount, and then both you and the buyer sign and date, or initial and date is fine too, yes.
Continuing on, buyer compensation from the seller,
Mhm.
okay? Pretty sure you can't do variable commission based on offer to the buyer side.
So you can do a variable commission.
You can. Because you get multiple offers.
I would suggest that, so variable commission has always been on the listing side,
Right,
okay? And it's been depending on who brings the buyer, or maybe depending on the amount. On the buy side, I wouldn't do that. For the same reason, on the buy side, there should never be an offer of a bonus.
but can you?
Maybe.
Okay.
I'm gonna,
So this is the scenario, the seller
Right.
receives 4 offers, right?
mhm,
Of varying amounts.
right.
Like a really high offer.
Oh, I have a new answer, go ahead.
Okay, but the terms
Mhm,
of buyer compensation varies.
Right,
So there's all these variables.
Right.
And so from a seller perspective, they might be, you know, I like that offer, but,
mhm.
so that's why I'm wondering, can they adjust?
I have a new answer.
Paying out, what is the answer?
Let me ask you a question first. Who does that benefit? The buyer or the buyer's broker?
Seller,
Let me rephrase.
okay.
If the offer of compensation to a buyer's broker changes based on the offer price, who does that benefit? The buyer or the buyer's broker? So let me expand.
Buyer,
I'll disagree with you.
Agent.
So if the offer price is this, you get this amount. If the offer price is this, we're gonna give you more. Who does it benefit?
not necessarily.
It can.
You're assuming that you're gonna get.
You're right,
more.
I am assuming, but those, and same thing with bonuses, by the way. Those higher offers of compensation to get a deal under contract by, or to get a specific offer price, are incentivizing the agent to convince the buyer to pay a higher
You're
price.
assuming that the agent will get the higher, and the way I was looking at it,
Okay, go ahead.
from a buyer point of view,
Mhm.
the buyer's, yeah, because it's all about what the buyer
Right.
wants. The
Okay.
agent is.
Then I misheard the
is
question.
the
Go ahead.
agent. I didn't say that, I didn't
Oh, okay.
include that information.
Oh, okay.
But in my mind, I was thinking to benefit the buyer,
Mhm.
right? Because the buyer, most buyers don't care so much what the agent's gonna make, they're more concerned with what
They
they're
will
gonna.
now.
What they're gonna, no. But given, it's like, do you care more about what you're gonna pay or more about what your agent's gonna make? They're gonna be like, I care more about what I'm gonna pay. See what I mean?
I agree
I just
with you
feel like
on
we're gonna
that.
run into all these complexities in the
Mhm.
coming months.
Mhm. There's a lot of confusion, and the best advice I can give you when thinking about circumstances like that is who is it going to benefit, and if it is incentivizing the agent to make the buyer do something that they weren't going to do without your advice, it is not a good thing.
Yeah, no, it was,
Yeah.
again, I was thinking from the buyer point of view.
Right.
But then back to the original question, definitively, can the seller offer variable commission on the buyer's side?
Maybe.
Still maybe?
I'm gonna go, and the reason for that is because you offered different scenarios. So I would say no if it was about getting the buyer's agent to make the buyer do something, because that, and the reason I say that is because that's kind of the way it was. Think about it
No,
from
I
the
know, but that's not
perspective
the way-
of,
From the scenario that I was saying,
Yeah.
there's multiple offers, right? Which we
Right.
get all the time.
I've heard, yeah, there's one or two,
You've
right?
heard, maybe, so, and there's gonna be, I think you see, there's, so obviously not only price, but terms and all these different
Right.
things we're looking at, right?
Right?
And if the situation arises where a specific offer might work better if the seller had the ability to change what they're gonna pay out, just wanna know, can they do that?
It may be possible. I can't, it's hard to give you a yes or no on that one. It's
I don't know why the
maybe,
context
I think
is-
what we'll do, maybe we can talk about this a little more later, and then just kind of work out different scenarios, because I really think it's going to depend. Just to speak about bonuses for a second, in the past, bonuses have been offered by sellers or maybe even listing brokers to get a property at a certain price or to get a property under contract by a certain day. And the reason I have the hesitation is because that was incentivizing the agent, not the buyer. So that's saying to the agent, get them in here, whatever you can do, and then we're gonna pay you this extra money. There should never be a policy that
Right,
will
well, I get that.
incentivize.
It's
So
not a
let's talk
policy.
about it some more, and then maybe we can go through some scenarios. Let me go over here first, I'll come back.
So just piggybacking off what Caroline said,
Mhm.
let's say you get 3 offers, all the same offer, and the terms are different in
Mhm.
terms of compensation.
Right?
Can you as an agent go back? We can't discuss compensation, right? Let's just say that the seller's looking at it, he's saying, Jackie,
This is a good offer, but the compensation is
Yeah.
too high, I only wanna offer this.
can we go back? We
As
can't.
as an agent of the seller,
Uh-huh.
because one of the things as agents we don't do is make decisions. You know that, right? We don't make decisions, we follow the lawful instructions of our client. So if the seller says, and we're the mouthpiece of the seller. So if the seller says, here are the terms, I like all of the terms except, and I'm countering with this. Well, there we go, here's the counter offer, and this is what they said, right? Yes, sorry.
Okay, so setting aside buyer bonuses and all that,
Mhm.
let's just put that away. In the listing agreement, we are putting the word may, seller may participate, right? So that may allows us to work with our sellers with a cost sheet, with all the different variables and terms, where they could go back and say, okay, I'm choosing this offer and compensating this rather than that.
The-
Because this is and that
Right.
is better for the seller.
Well, unless the seller has definitively said, this is the offer I'm giving. This is the amount that I'm giving. So it's really hard to negotiate that after you've publicly said, this is the amount that I'm giving.
But you're not
right?
gonna really say, because you're saying may.
But there are brokerages who are, right? So in our case, it's best that we don't do that, right? Because then that allows the seller to evaluate it and say, okay, I'm looking at all of the terms, right? And yes, this compensation makes sense for the offer that I received. And then I'll come in Simon, but I want to also mention that one of the things a question that I've got has been about, well, how do we prepare the seller for that? Because we can't discuss other brokers' compensation, And you can't say, well, usually the fee is, or typically this is what a buyer broker is paid. We can't have those conversations with the seller. So my suggestion has been, give an example to the seller. When I represent a buyer, this is what I charge. So if I'm bringing a buyer to you, this is what you can expect the request to be if the buyer wants to. And that sort of prepares them without, having that conversation. So,
Can you go a little bit more deeper on unrepresented buyers when it comes
Sure.
to open house
Mhm.
or how
Yeah.
that works?
So unrepresented buyers, or a buyer represented by another broker. When it comes to an open house, you are there representing the seller or the landlord. You can absolutely tour them around the house. You can actually absolutely give them facts and information about the house or the rental, whatever it is. You just can't give them advice. You're not their agent. With an unrepresented buyer, our listing agreement has a space in there for unrepresented buyers, which is an increase in the commission with the seller, because there's going to be work that we're going to have to do on behalf of the seller to help that buyer by attending home inspections but not giving advice, attending appraisals but not giving advice, right? So there's things that we're going to have to do. The buyer's not going to get representation. It's not a good idea for a buyer not to have their own agent. But you can have the increase the fee in the event an unrepresented buyer comes to the table. It's the flip of a FSBO, where you're working with the buyer, but you have to give the seller the seller's disclosure to complete, the lead-based paint disclosure to complete, all of these other things that they are supposed to have as a seller for the benefit of our buyer, right? So it's just kind of the flip of that.
But why can't you find a designated agent? in
Well,
this
it
case?
depends. There are some buyers who don't want representation, so that's where that unrepresented buyer comes in. In my opinion, no buyer should be unrepresented. They should have advice, actual professional advice. That's why we're here, right? Look at the number of FSBOs that put their house on the market, and the percentage of them that convert into listings with brokers, because they can't do it on their own. They don't know how to do it on their own, and that's why they need an agent.
And that would be different than disclosure agent.
That is correct, because one of the things that is a common misunderstanding in a real estate transaction is that all parties have to be represented. So you're representing the seller, and a buyer approaches you and says, oh, I'm interested in the house. Okay, well, here's all the paperwork. I'm your agent now, a dual agent, and all of it. Well, did you discuss representation? Did they ask for representation, right? So in most circumstances, it's, dual agency now will mostly apply to the same agent representing both parties in the transaction, right? But it's a good idea for them always to be represented, but it is their choice.
If they don't want to, do we have a piece of paper that says they're gonna sign to say they know they're being unrepresented?
Our brokerage does. It's called,
100%.
disclosure of
Unrepresented.
non-representation or something
They
like
realize
that.
yeah.
So it's very, very clear.
Right,
We don't represent you.
okay.
But then you still have to fill out the contract and all the other people.
Yes, unless they have an attorney do it. So again, you can fill in the numbers, you just don't give them advice on what to fill in, right? You can fill in the numbers and have them sign it. But again, to make sure that there's no confusion, the best thing for them to do is have their own agent, or you be their agent, or have an attorney. Can I mention one thing about attorneys and contracts? The New Jersey Realtors contract, or any contract that is prepared by a licensee in New Jersey, must include the attorney review clause. That applies both for sales and leases. That means that the contract is subject to review by an attorney after it's been signed, right? if an attorney prepares a contract or a landlord provides their own lease, that is not subject to attorney review. The moment it is signed by both parties, it is in effect, right? So if you are working with a landlord, or you're working with a tenant and a landlord provides their own lease, it's a good idea for that tenant to have that lease reviewed by an attorney before they sign it, okay? And if an attorney prepares a sales contract, let's say a buyer's attorney prepares a sales contract, or the seller's, or whatever, either side, the other party should have it reviewed by an attorney before they sign it, because it goes into immediate effect. It's immediately under contract.
But in case there is a standard brokerage firm contract, it shouldn't be reviewed by attorney? Or
It doesn't have to be reviewed in advance,
No, after
but it can be
signing.
reviewed after signing, just like our normal process.
Is it a mandatory for a lease now?
Always has been. If you read the New Jersey Realtors residential lease, it is in there. It is in there. Leases, residential leases can be canceled by an attorney during the attorney review period.
In other words, it's mandatory or not?
It's mandatory state law. Must be in there. They don't have to, just so that I'm clear, landlords and tenants don't have to have the contract reviewed. They don't have to go through, an attorney review period. But technically, the lease does not go into effect, and it's not actually binding until 3 business days after it's been signed and presented to both parties. Yep. I've actually, in my career, I've had 1 lease canceled by an attorney. Showed up with a letter. Yes.
Okay.
And tell me when I need to stop.
Yeah.
I just wanted to wrap up the last question. Okay, yeah, that's what I was gonna say. Everybody, Jeff, hopefully you're gonna stay for lunch with us.
I will.
If we have questions, and also Peter and John are here, and I think it's super helpful for like mortgage questions. There's a lot of nuances and what they're actually seeing and have to dealing with.
That's amazing.
I think are gonna be helpful for people to ask them questions too.
The more info you have, the better.
Yeah. So
Great.
you all are like between Jeff, John, and Peter. You guys are on the front lines more than any of us, just in terms of the volume you're already seeing of what's happening. So thank you again to all of you for the great research you all.
And thank you all for listening to me.